Hello everyone, welcome to topic of the day. Now Supreme Court upholds 10% quota for the economically weaker section. So today let us discuss what has the Supreme Court ruled on the quotas. So by a majority of 3:2, a 5-judge bench of the Supreme Court has upheld the validity of the Constitution 103rd Amendment which came into effect in January 2019. Let us discuss about 103rd Amendment. The 103rd Amendment inserted Articles 15 Clause 6 and Article 16 Clause 6 in the Constitution to provide up to 10% reservation to the economically weaker sections among non-OBC and non-SC/ST sections of the population. In other words, the amendment had changed the Constitution and introduced a quota for the poor among the so-called forward castes or general category. The quota is available in admissions to the higher educational institutions and in initial recruitment in central government jobs. The amendment also empowered state governments to provide reservation on the basis of economic backwardness. Now let us discuss how does the government define economically weaker section. The EWS criteria for employment and admission was notified on 31st of January 2019 by the Department of Personnel and Training, DOPT, based on the 103rd Amendment. So, under the 2019 notification, a person who was not covered under the scheme of reservation for SCs, STs and OBCs and whose family had a gross annual income below Rs 8 lakh was to be identified as EWS for the benefit of reservation. Now, let us discuss about the challenges to the 103rd Amendment. First of all, the amendment was challenged and was referred to a 5-judge constitution bench in August 2020 based on the argument that 103rd Amendment violated the basic structure of the Constitution. It is because the special protections guaranteed to socially disadvantaged groups is a part of basic structure and that the 103rd Amendment departs from this by promising special protections on the sole basis of economic status. Now, the Supreme Court introduced the doctrine of basic structure in the landmark Keshwanand Bharati case 1973, by which it ruled that certain aspects of the Constitution are inviolable and could not be changed. Now, let us talk about the recent verdict by Supreme Court. 3 out of 5 judges have upheld the validity of the 103rd Amendment. They ruled that reservation based only on economic criteria does not violate the basic structure of the Constitution and that the exclusion of classes covered in Article 15 Clause 4 and Article 16 Clause 4, that is OBCs and SCs and STs in the 103rd Amendment, does not damage the basic structure. So, treating EWS as a separate class would be a reasonable classification, and that treating unequals equally would violate the principle of equality under the Constitution. Now, 75 years after independence, it was time to revisit the system of reservation in the larger interest of the society. So, who are the judges who have dissented? The minority view came from 2 judges, including Chief Justice of India U. Lalit. They ruled that while reservation on economic criteria is per se not violative of the Constitution, excluding SC, ST, OBC from the purview of EWS is violative of the basic structure. Thus, they down Article 15 Clause 6 and Article 16 Clause 6 for being discriminatory and violative of the Equality Code. Now, the question arises, what about the 50% ceiling on quotas? The majority judgment appears to have struck down the ceiling. Justice Maheshwari said that the reservations for EWS does not violate basic structure on account of 50% ceiling limit because ceiling limit is not inflexible. However, Justice Bhatt on the minority side said that the permitting breach of 50% would result in compartmentalization and the rule of right to equality will become right to reservations. The Supreme Court has repeatedly underlined the 50% ceiling on reservations imposed by the landmark Indira Sahani judgment of 1992. On that basis, attempts by a number of states to provide reservations to specific groups have been struck down. Thus, several of those issues can now be reopened. So, this was a little bit about the topic. Now, let us take up one practice question on the same. Consider the following statements regarding reservations to economically weaker sections. First, the 113th Amendment inserted Articles 15 Clause 6 and Article 16 Clause 6 in the Constitution to provide up to 10% reservation to the economically weaker section among non-OBC and non-SC/ST sections of the population. Second, under the 2019 notification, a person whose family had a gross annual income below Rs 6 lakh was to be identified as EWS for the benefit of reservation. Now, which of the statements given above are correct? You can take a moment and write your answers in the comment section below. So as we know, both of the statements are incorrect regarding the reservations to economically weaker sections. Therefore, the correct answer is option D, that is none of the above. And with this, we call it a wrap of today's session of Topic of the Day. I hope you liked the video. I will see you with some other topic tomorrow. Till then, take care and do stay tuned.